We are scheduled to talk about slips, trips, and falls, and there's a lot of the same things that go on in Louisiana as it is in the states that I'm licensed in, Alabama, Georgia, Florida. We've kind of got a slide here to kind of go to about why a business owner may be responsible or why a business owner is not responsible during given times. And so let's take a look at that. So a business or property owner is liable if they cause the unsafe condition. We can talk about that for just a few moments. If they knew about the unsafe condition and ignored it, or should have known about the condition and failed to warn about it. So let's kind of break that down a little bit. All that's kind of the same in Louisiana as it is Alabama, Georgia, Florida. Isn't that right, Johnny?
Yes, absolutely.
And so let's kind of give an example. Let's kind of come back up on us here a little bit here. Let's give an example of something where a premise owner or a landowner, I had a law student ask me, our law clerk, he was finishing out his law term, what is a premise? So let's kind of break it down. It's a landowner. It's or a piece of property. So when is a landowner responsible when they've created a condition? Can you kind of give me an example of that, Johnny?
Certainly. Probably the best example I can think of off the top of my head is just a retail establishment. Say you're in a retail facility or a hardware store and they leave some piece of wood pipe out and you trip on it and it shouldn't have been there, and that landowner, that hardware store put it there, they're going to be responsible for any of the damages it caused when you tripped and fell on it.
Yep. And how about where somebody knew of an unsafe condition and kind of ignored it or didn't get to it? Sometimes, at least over here in Florida and also in Alabama and Georgia, the transient foreign substance, something that was left on the floor, thrown down on the floor. It wasn't necessarily created by the establishment, but again, kind of a retail situation where there's cheese whiz on the floor or baby oil on the floor or a grape on the floor. Tell us about those kind of situations, and I think again it's the same thing everywhere in these areas that we're talking about.
Right. Those cases can be very difficult to win, but the better cases are the ones where if it's an ice cream that fell out of a shelf and it's melted on the floor, it's been there for a while. And if it's been there for a while, then the owner of the business, Walmart or retail stores, they should have had an opportunity to go clean that up, make it safe for their patrons, and if they didn't, then they're going to be responsible for it. And like you said, most of the hazards that are created at retail or grocery stores, Walmart, typically caused by the customer most of the time.
Right.
So that's why you're going to look for a substance like, was it ice that melted? Was it an ice cream that melted? Things like that. And just depends on how long it's been there and what their cleanup operation requires them to do. That's going to dictate whether they're going to be liable for your injuries.
And the law on that is, what's a reasonable time? And you and I were talking about it here. There's a little bit of a difference in Louisiana to Alabama, Georgia, Florida. In Louisiana, what is a reasonable time for somebody to come clean something up, Johnny?
And I guess that depends on quite a few things, like what type of store is this hazard at, what are the safety protocols they have in place. If they have something in place where they're supposed to be monitoring the floors every 5 or 10, 15 minutes and they don't, then that's going to be enough. But if it's a retail establishment or something where they don't have people on the floor all the time, then that time is going to be extended. So it's really very flexible.